students. Today in this session, you and I are going to find answer to a difficult question, a question that we all relate to. That's about our environment, the nature around us. And the question is, what is the status of nature in our lives? As law students, this effectively means exploring the legal personality of nature. Well, you'll say that what's new in this topic? Christopher Stone had 50 years ago argued that what seemed to be a very whimsical argument then, that trees should have a locus standi in the court of law. It should have a right to be heard. All in all, it should be declared to be a person. And he supported his statements by an analogical argument. He said, long time back, children didn't have rights, nor did women, nor did the slaves. They were no more than chattels. Giving chattels legal rights was just unthinkable at that point. He said, until the rightless things receives its rights, we cannot see it as anything but a thing of use to us. 50 years down the line, we are still deliberating. Meanwhile, there have been voices against granting legal rights to animals. For in a rights based legal system, when the state by a law compels X to do or forbear from doing something towards Y, and this is backed by sanctions, it means that Y has a right and X is duty bound by law to comply. It therefore means that the right duty relation coexists, and so does the right holder duty bearer relation. Without one, the other becomes meaningless. This relation, therefore, cannot exist between a person and a thing or a property, such as a car or a pet animal, as they wouldn't be in a position to reciprocate the right or the duty. There is another objection to the grant of personality or legal rights to nature. The act that is central to the right duty relation, that is, to do or refrain from doing of a certain thing, requires voluntary physical movements or consciously willed absence of physical movements. This consciousness being absent in the act of an animal, river, or a tree makes the act incapable of legal consideration. In other words, though animals are capable of acts and possess interests, their acts are neither lawful or unlawful. Consider this. If an ox were to gore a human, should we attribute liability to the ox and punish it? Well, many years back we did. But soon human society realized the futility of it. If a buffalo were to trespass on my flower garden and destroy the flowers, would it make sense to punish the buffalo? Or would it be better if I could be compensated for the damage caused by the owner of the buffalo? Similarly, if someone injures my pet dog, rendering it incapable, it is a wrong cause to me. Think of this. If I were to will my property to be given to my favorite pet Smokey, what would Smokey do with the property? It would neither have the inclination nor the means to be able to enjoy the property for its own benefit. The purpose of provisioning for Smokey after my death would not be achieved as Smokey is incapable of executing the property for protecting its own interests. Now consider this. If I were to will all my property for the benefit of stray dogs in my locality and to that effect create a trust, in that case, there would be persons executing the trust in a way as directed. Whatever part not so spent would return to the legal heirs of the testator. But the stray dog would be benefited by the trust. Have you heard of the Prevention of Cruelty to Animals Act? Unnecessary torturing of animals is an offense under this act. Does it imply that animals have a right to life? These last two instances may mislead us to think that animals have some rights, but that's not true. In fact, these duties towards animals are in fact duties conceived by the law as duties towards society itself. They aren't duties towards the animals nor do the animals have rights towards the compliance of these duties. These are public rights vested in the community, recognized by law, a rightful interest in the well being even of the dumb animals which belong to it. In other words, law is made by humans and show no solidarity for mute animals. But are all animals dumb, have no emotion or expression? How about a chimpanzee? It certainly depicts far more autonomy and self determination as compared to my Smoky. Shouldn't at least the chimpanzees be recognized as having legal personality? This was at the center of the deliberations in the matter of Non Human Rights Project Inc. versus Stanley in 2015, wherein the court stated that autonomy and self determination of an entity are not regarded as the basis for granting it rights. Previously, the Lavery Court in 2014 had also held that animals cannot hold rights and duties, and that is essential to the grant of legal personality. In 2010, Morris and Ruru published an article titled Giving Voice to Rivers. Here they argued for grant of legal personality to rivers. Their justification was twofold. This would be in sync with Maori traditions, and it would help in roping in the services of the community and thereby facilitate river conservation. Recent decisions worldwide are making a shift towards according rights to nature. In 2017, the Whanganui River in New Zealand was declared to be a legal person. Likewise, Argentina, Bangladesh, South Africa, Mexico, and many others have recognized rights of nature, be it in animals, rivers, and the like. In India, the court observed that all species have an inherent right to live. In 2015, the Delhi High Court stated birds have a fundamental right to fly and not be caged. In 2017, the Uttarakhand High Court granted personality to rivers. In 2018, the Madras High Court stated that state is duty bound to save mother nature. In 2019, Punjab and Haryana court declared that animals have legal personality. Unfortunately, in all these cases, the courts have invoked parens patriae to impose obligations either on the state or an entity of the state, where in most cases the grievance is the failure of the state to implement the laws. The right to nature movement or ecocentrism stresses on the intrinsic value of nature. This is why nature deserves moral consideration. But our environmental law policy and principles rely on intergenerational equity, the seventh generation sustainability principle, polluter pays principle, precautionary principle, or even rights of nature, where we place human needs at the center of all environment versus development decisions. More so because the concept of rights itself is people centric. In so doing, we aren't really ecocentric, we are anthropocentric. We have a long way to go from anthropocentric to ecocentric, from according personhood and rights to nature because we understand their value to us, to actually valuing nature around us for its own sake. So I leave you with a question here. Let's find this out in the next session. What changes in our thoughts and patterns of behavior would make our actions more ecocentric? Thank you.